From iAfrican Media, this is iAfrican Bites, a podcast that features commentary on African news, insights, opinions, and analysis with tech industry leaders and professionals. The podcasts are from interviews conducted by the African team, whether at events or when needed for commentary. I'm Bataon Khosokwane, host and editor-in-chief for iAfrican.com, spelled www.iafrikan.com.
On the 19th of April 2023, the Democratic Alliance Shadow Minister of Communications, Deanne Kola Barnard, issued a scathing written response to the Minister of Communications, Mondle Gungubele, alleging that the ruling party, the African National Congress, is blocking Elon Musk's satellite company STARLINK in getting an ISP license that would enable STARLINK to sell internet and data services. Now, numerous stories and news articles and media reports on this matter have appeared since the letter. We at iAfrican believe strongly that there's a lot of grandstanding in this case and that there's been little to no legal or factual argument to back the claims. Now, in this episode of iAfrican Bites, we're joined by Lucian Pierce from ICT firm PPM Attorneys to understand the compliance considerations that are required by the regulator to be granted an ISP license. Lucian, on ICASA's updated list of individual electronic communications network service licensees, there's about 501 companies and juristic persons, right? I say juristic because there's close corporations and sort of other formations there. Walk us through what typical requirements and application processes do all companies undertake with ICASA, the regulator, for an ISP license?
Okay, great to be talking to you again, Patang, and definitely a really interesting topic that I think requires a bit of clarification, perhaps. Now, before we get into your question, perhaps what I can do is give a very brief 101 on licensing in South Africa. Now, as you rightly pointed out, ICASA is the regulator that governs the types of licenses that ISPs and broadcasters would use in South Africa. Now, there are two types of, if you want to use the colloquial term, ISP licenses, electronic communications licenses. The one category is for services and the other is for infrastructure. Under that, are an additional two categories. We have what are called class licenses, and we have what are called independent licenses. Now, class licenses are relatively easy to get. So you can get a class license to be an ISP. You can get a class license to provide all kinds of electronic communication services. But the ones that you are referring to, that over 500, the number of over 500, they have what is called an independent electronic communications network service license. So the key word there is network. And network refers to having some sort of infrastructure that you put up, that you build, that you invest in. And so to get that type of license isn't that easy, actually. The 500 or so companies that have that license would have either gotten that license a long time ago when we had an old act called the Telecommunications Act, and there was a big court case that allowed them to convert their old types of licenses to new licenses, the ones that we see now. The other way that you can get this very difficult to get license is when the Minister of Communications tells ICASA to issue an invitation. And those invitations don't happen too often. And the way you would get that license is you would literally have to go through a type of assessment that would look at management, that would look at your finances, that would look at the skills that your staff have, your commitment to procurement, and a whole lot of other factors. So those licenses don't happen too often, and like I said, are typically by way of an invitation, and that happens every now and again, every few years or so. So it's not easy to get those licenses. I hope that gives you a good overview of how to get that license. Yeah.
100%, 100%. Now, with that said, I think you've really set it out nice. What is the typical requirements and application process to that a company would undertake for that specific license? This is now the infrastructure license.
Yeah. So the way it would start is the Minister of Communications, for one or other reason, might identify a need for this type of license. Now, to give you practical examples, mobile services providers like Cell C, MTN, Vodacom, and Rain, they have this independent communication network service license. And MTN and Vodacom, for example, would have applied for or would have responded to an invitation in the 1990s, that long ago, to apply for their licenses. More recently, companies, would have obtained these licenses through the spectrum auction, for example, last year. Okay, so the minister tells ICASA, right, ICASA, we need a particular type of infrastructure license to be issued. That's called a direction from the minister. What happens then is the minister steps back and ICASA takes over the process. That process is regulated under the Electronic Communications Act, and there's a special regulation under that sets out the step-by-step process that ICASA needs to follow to issue that invitation, to assess and adjudicate the applications that are put in, and to give reasons why it might decide on one or other applicant. So it's typically a competitive process when these licenses are issued. So there's no guarantee when the invitation comes out and you respond to it that you are going to get that particular license.
Lucian, well understood. It's clear. Now, all countries have policies and laws in regards to localization. These ISP applicants or licensees to have a minimum 30% set aside for equity ownership to be held by persons of historically disadvantaged groups. Now, when did this 30% equity ownership requirement regime start? Basically, how long has it been law?
So this has been around for quite a few years. It's nothing new. It's in excess of 5 years since that minimum of 30% was. It's longer than 5 years since that 30% was put in place, and there's always been a requirement to fulfill these equity requirements. Every invitation to apply that has been issued over time will look at and assess that element, which is a main and a very important aspect of the adjudication process. So it's not something new at all. It's been around for a long time, and it's always formed part of, as you mentioned, some of the policies of the country that have been in place for many years. So it strikes me as rather strange that this is being raised as an issue now, when it is part of what the country is trying to achieve to right the wrongs of the past, if I can put it that way.
Now, Lucian, typically with any sort of policy, here and there are exceptions. Now, has there been any exceptions to this regulatory requirement, either in practice or case law in the past?
Look, not that I know of. Ever since this minimum requirement has been in place, almost all the applicants that I'm aware of, take the spectrum auction process last year, would have been required to have that minimum equity requirement. So there was no fuss that was made last year when the auction took place. And in fact, quite a few licensees applied to buy some spectrum, and they were granted it, and there was no issue or fuss made about it at that point in time. So that 30% equity requirement was in place then too.
The reason why I'm asking this is because on the ICASA ISP list, all right, there's JAC listed companies, household brands such as Vodacom, your Kechimas, and MTNs. Would I be right to say that even these $1 billion or billion rand companies have also been required to cede 30% of equity to be in line with the regulation.
So what has been provided for is ICASA, the regulator, did recognize that at some point, some of these licensees would not have had that minimum 30%. So it published regulations, might have been 2 years ago, thereabouts. And what those regulations stipulated was that it afforded each of these licensees a period of time, if I remember correctly, it was 4 years from that point, to remedy that shortfall of 30%. So even if any licensee doesn't have that, there is they need to comply with that new regulation whereby they would need to increase the amount of equity shareholding to 30%.
So it would require sort of like a plan or an assurance to say that in the future we will undertake to shed some 30%, whatever share scheme that they do it, but there's typically some sort of undertaking that will undergo that process, and within 5 years or 10 years or whatever the case may be.
That's correct. Yes, in fact, those regulations require the licensee, the Vodacom or the Cell C or the MTN, periodically to update ICASA on how it is progressing towards achieving those targets.
Now, Lucian, on an international comparative analysis, is this a standard practice globally to become ISP licensed in other jurisdictions?
So I haven't done too much research on other jurisdictions. I'll talk very generally from dealings with other jurisdictions. And I'm aware that this is not a unique requirement. I'm aware it might even be Saudi Arabia, that if a foreign a business is setting up there, that there are requirements with regard to having local ownership. I don't know what the proportion of that is, but I'm aware that, for example, Saudi Arabia has that requirement. So this is not an unusual requirement from what I'm aware of.
Lucian, in your knowledge on this 30% requirement, has there been ISP applicants or licensee holders that have challenged this 30% requirement in the past or currently?
I'm not aware of any formal challenge, for example, in the courts. What I am aware of is that during consultation processes, so ICASA doesn't simply pull these regulations out of a hat. It would normally publish draft regulations for public comment. And in those instances, anybody who is an interested person would have an opportunity to comment and oppose those objectives, for example, this minimum of 30%. And, ICASA then, if it continued to make that requirement obligatory, would have to give reasons as to why it stood its ground and set that target. And as far as I'm aware, nobody has challenged that formally. It's been always a comment in the form of comments, but I'm not aware of anyone objecting to that minimum requirement formally in a court of law or some other tribunal.
The thing I'm trying to ascertain, based on the procedural process that you just outlined, that's applicable to everyone, whether SMME, whether JSE listed, ISP, is there a special factor in the STARLINK matter that would warrant an exception to the rule?
No, I can't see any reason why STARLINK would need any preferential treatment. The long and the short of it is, if STARLINK wanted to set up in South Africa, it would either need to wait for an invitation to be issued, which is not ideal. Another way it could set up is to actually buy one of those over 500 licensees. Of course, that process would need to go through approval by ICASA. so everybody else has to do that, and I can't see what is special about Starlink, being given preferential treatment. Let me give you another example. In that process of obtaining the required license, Starlink would also need to apply to ICASA for what we call frequency, because the way Starlink operates is it sends signals, just to use a colloquial term, down from a satellite, and people get those signals and they access the internet. But those signals don't just appear magically. They use frequency, radio frequency, which is a precious spectrum for any country. And Starlink would then also need to apply to get a certain amount of spectrum to do its to run its business here. And all of that needs to be regulated, or else you would have chaos. So those rules, those regulations are there for a reason.
Now, ISP, Lucian, play a very critical and sensitive role in the country. They're connecting millions of people and businesses, and they handle a lot of sensitive and confidential data. Now, with the global concerns around cyber espionage, the banning of TikTok in like the USA and the EU, what security concerns would South Africa be exposed to? Or rather would expose itself in having an ISP company that's 100% owned by a foreign company, with no office in the country, with no internet assets on South African soil?
Well, it certainly, presents a risk, whether it be Starlink or whether it be some other satellite internet service provider. There certainly are issues that arise. Of course, one would imagine that Starlink and its shareholders would want to, would never want to compromise the company's reputation by being involved in anything like that. But there aren't any guarantees. We've seen time and time again where these types of services, whether as a result of state interference. So take Edward Snowden in the United States, that's an example. Or you could take our very own South Africa here, where a few years ago, the Constitutional Court ruled that the bulk surveillance of internet lines was illegal. Very similar concept to what happened in the United States. Now, in those instances, the ISPs were not complicit, but certainly there would be an instance where perhaps an ISP like Starlink, and I'm not saying they would do that, may be compelled by some sort of secret court order in the United States to produce certain information. So that's just theoretically. I certainly expect that Starlink would push back. And it is quite common for many ISPs and other similar providers to push back. I'm aware of reports that are published every year by companies like Microsoft, by companies like Amazon, where they state the certain types of requests that they might have received from governments for surveillance, and in certain instances they fight in court. So there's always that risk as well of having a foreign service provider carrying traffic over the internet from South Africa.
Now, in closing, Lucian, it's just in your closing remarks, how would you sort of advise citizens and just our listeners to look at the story? How does one make sense of there's this Starlink its owner is one of the most popular person. He's the most popular person in the world, if not on Twitter, right? So it's making all this noise, it's making all this attention. How do citizens, South Africans, look at the story? Some South Africans might be looking at the story, confused, like, but we want Starlink. Why is the government refusing? Like, how do we make sense of the story?
Look, when I saw the story breaking and read the assertions or allegations that were being made by various politicians, I certainly was taken aback, because the process of obtaining the required license is very straightforward. Starlink is not banned in any way from approaching ICASA to make inquiries regarding what type of license it needs. All it needs to do is perhaps speak to local telecommunications lawyers, and I'm not fishing for work here, but they would have been given clarity that there are various ways for them to obtain the requisite license. So in my view, it really was unfair to make the allegations that were made about STARLINK being blocked. If STARLINK wishes, it can get the license it requires. Our laws have certain minimum requirements, and if it complies with those minimum requirements, it will get the license. I'm quite sure of that. So it hasn't been blocked, and the way that the story has presented, in my view, has a lot of smoke and mirrors around it.
Listen, Pierce, thank you so much for your time. Thank you so much. As always, a wealth of knowledge, a wall of knowledge. And yeah, looking forward to having you back.
Thank you for listening to iAfrican Bites. Please share your feedback with us on our socials. On Twitter @iAfrican, on LinkedIn @iAfrican.com. And check out our other podcasts, The Tefo Mohapi Show, Take Legal Matters, and The Lead Creative on all podcast streaming platforms. And also make sure to head over to www.iAfrican.com. That is iafrikan.com/radio, and subscribe for notifications. iAfrican Bites is an iAfrican media original show produced by Nzalo Mbangana and content producer and host by Don Kotokwane.